My name is Brian Massey. I'm a partner at Kunzler IP. I've been practicing in patent law for about 10 years now. My background is in mechanical engineering. But the topic I'm talking about today applies across all technology areas, and it is the common pitfalls to patent procurement. A lot of times an inventor will come in to get a patent and will be very disappointed to find out that his actions that he engaged in before he talked with us are going to prevent him from getting a patent. And that's quite a surprise and a disappointment. So we're going to talk about a couple of things here that happen before a patent is filed where the patent attorney is typically not involved. So the inventors need to be aware of these things so they don't engage in any activities that could prevent a future patent. There's two different actions. There's going to be actions, your own actions that you engage in, and then there's other actions. Of course, other actions, there's nothing you can do about that. Some other actions by other people is that maybe they invented your invention before you did, which is prior art against you, which will prevent you from getting a patent. Again, nothing you can do about that. Your own actions, what things that you can do, there's post-filing and pre-filing. With post-filing, there's a lot of things there that I won't really get into. Inequitable conduct, prosecution history estoppel, there's inventor issues. But at that point in time, typically you're going to be involved with a patent attorney who can guide you along that process and help you understand the ways to avoid those type of actions. The pre-filing stuff, that's where a patent attorney may not be involved. And these are things that you need to be aware of before you start to monetize your invention, before you start to go out and tell people about it. There's a thing called a statutory bar. And basically, it kind of means what it says, that the statute in the United States will bar you from obtaining a patent if you engage in certain activities under certain circumstances. In the United States, if you engage in one of these statutorily barred actions, you have a grace period of 1 year before you need to get an application on file. If you miss that 1 year, if it becomes a year and a half or 2 years or longer since you engaged in one of these statutorily barred activities, you're simply out of luck. You cannot file a patent. You're statutorily barred. It doesn't matter if you invented it 50 years ago. It doesn't matter when your invention date is. You're barred from getting a patent. Now, that's the lenient approach. In most foreign countries, in fact, nearly all foreign countries, there is no grace period. So if you engage in one of these activities, you're barred from obtaining a patent in those countries. So it's a very severe punishment for engaging in that activities. That's why it's even more important to understand what these activities are. So the first one is publication. If you publish your invention in a journal, at a trade show, in some flyers, on your website, things like that, anything that can be publicly accessible by the general public at large would be considered a publication, whether it's in the United States or in any other foreign country. So if you throw something up on your website and say, shoot, and I shouldn't have done that, and you take it off, well, the website is going to be cached, and technically it's going to be publicly accessible. If you take one piece of paper and you put it into a library, and it's accessible at a library in some place, anywhere in the world, it's a publication, so you need to watch what you do as far as publishing your invention. Public use is, and on sale, these next two are just actions in the United States. So you can engage in these two in foreign countries and you'd be okay in the U.S. The first one, public use, is kind of like what it says. If you go out in the public and start using your invention in a variety of ways, that could start the 1 year grace period time clock. For example, there is a situation where someone invited his friends over to his house. He pulled out the invention, showed it to them. Look how cool this thing is. Depending on the number of people that saw it and the intent of showing it to your friends, that is possibly a public use that would start that 1 year time clock. Again, this is all going to be kind of a totality of circumstances. A ton of facts are involved. There's really no cut and dry situation. But suffice it to say, the more people you disclose it to, the more time it's out in the public and you're using it, the more likely it's going to be a public use that'll start that 1 year clock. What if you have a cool new engine that you throw in a car and you drive it around the town, but you're not showing it to anyone. No one can access it. No one can even see it. It's in use, in public. So it's a public use. And that can be an issue. So one exception to public use is if you need to experiment with your invention to see if it works. And the only way you can do that is if you actually go out in public and use it in public. There was a case a long time ago about somebody who invented, I believe it was a new concrete that that you paved the road with. And the only way he could really see if it lasted long term, like he claimed, was to go throw it on a road and see how long it lasted. And of course, that road could be in the public domain and could be publicly accessible. Nevertheless, it was an experiment, and therefore it didn't start the one-year time clock. As far as experimentation goes, if you have non-disclosure agreements in place and you have a pretty tight control over who sees the results of your experiment, who has access to your experiment, the more you have those type of protections in place, the more likely it would be considered a public or an experimental use exception to the public use statutory bar. But again, it's not cut and dry. So you want to consult with a patent attorney to get a better idea of, is this experimental use, is it not, is it going to be considered public use? I better find out. And the last one is on sale. If you offer your invention for sale to someone, even if it's private, in a private setting, in an office, for example, it could be an on-sale bar. The only real requirement that you need here is, well, there's two. One, your offer has to be, if it's acceptable, you have a form contract. The other requirement is that your invention that you're offering for sale needs to be in a condition for patentability. In other words, you could actually, you know enough about your invention, you could file the application at that day, on that date, at that time. If those two conditions are met, your on-sale bar to your neighbor in your basement in a private setting could potentially invalidate your patent if you ever got one. So be aware of that. The bottom line is, the advice that I would give is consult with a patent attorney, but before you disclose it to anyone else, especially if you don't have a non-disclosure agreement in place, to consult with a patent attorney and find out what ramifications that disclosure may have. Because again, you may get a patent through the patent office and have a lot of product in place and be making a lot of money, and someone can swoop in and sue you and invalidate the patent because of one of these reasons unbeknownst to you. So that is it.